was reading through it yesterday, a really interesting selection of articles and opinions that I think really testifies both to the vibrancy of human rights discourse in this day and age in terms of its intersections, also with a lot of sort of social and cultural issues that we're confronting in 2020. I'd also like to thank everybody in the audience today, and I'm looking forward to sort of fielding some questions. And also, of course, to Pavan for a very interesting and well-informed discussion. And also to Felipe. And I think possibly I'd like to talk about some of the commonalities or points that have resonated with me about Felipe's piece in terms of introducing my own article. So first and foremost, this is an area that I'm very interested in, and similar to Chris, I think I've taken a very sort of Eurocentric view to it. I've thought that, the European Convention jurisprudence was sort of enough on this, and it's tremendously interesting to have this comparative perspective on it, and I think something that's very valuable both for the journal and also for human rights discourse as a whole. And I think the thing that possibly kind of underlines or undergirds Felipe's discussion is this sense that the accommodation of cultural minorities is something which has been funneled into our legal architecture, but it is eminently a social and a cultural consideration. And I think there's an interesting balancing act that has to be done both legally and institutionally in the way in which we confront and separate the social realities and, I suppose, some of the legal fictions that we have to impose onto those difficult realities. So I'm going to be talking today about one of the more difficult social realities, and that being the state of a society in the aftermath of genocide or serious controversy and atrocity. So my inspiration for this piece came from reading about and visiting Bosnia, speaking with people who've been affected by the Yugoslav war and the Bosnian genocide, and trying, and I think probably failing, to kind of impose or sort of incorporate that into my way of thinking about it legally. And I felt very, very strongly that there was this clear dichotomy between these immediate social issues and their translation into legal forms, which I think is something that's tremendously problematic and difficult. So I was thinking about this in terms of the cultural legacy of genocide, because genocide is fundamentally, even though the legal definition of this didn't in the end up including the factor of cultural eradication, it is primarily not just, it's greater than its sum. It's not just sort of how many murders and instances of sexual violence and ethnic cleansing, but it's also this more intangible sense that a particular minority, most often an ethnic minority, has no place in a society. So I was looking at ways in which, in post-genocide society, human rights remedies can be used to rehabilitate an ethnic minority that has been affected by genocide or by serious human rights violation. So this required me to take a look at the sort of the human rights architecture through which this is usually expressed. And I think there were two really clear limitations on the way in which we talk about human rights violations and the way in which we resolve them legally. So first of all, there's the personal scope of human rights violation. We imagine human rights as being broken by a state against an individual. At least as human rights lawyers, that's what we're taught to understand. However, the extent of something like genocide is far beyond the people who are immediately affected. It's families, it's communities, it's something that vividly affects diaspora in other countries. And it's something that can't really be forced into that matrix of individual suffering. The second one is the temporal scope of those violations. I think it's almost presumed in human rights adjudication that what you're talking about has finished, that violation is something that you're able to quantify retrospectively. However, I think with something like genocide, I would argue that it's still something that reverberates around, I look primarily at Bosnian society, but also look at instances in South America, not of genocide, but of similar ethnically motivated violences. So I think the important thing that I was looking at here is a way in which you can foster both a collective and an intergenerational consciousness of a human rights violation through remedies, and one which doesn't finish with pecuniary compensation, monetary compensation, or some singular award that is supposedly going to solve what has happened. I think in any case, any remedy of that sort is going to be inadequate. So I was looking then at ways in which that can be achieved. And I looked to the jurisprudence of the Inter-American Court for Human Rights, the regional court responsible for human rights violations in South America primarily. And I was drawn to this sort of growing jurisprudence of symbolic and commemorative remedies. So this involves cases where, even in this case, sort of individual suffering could be commemorated by a court-ordered commemoration of a park, a school, a road, whatever it may be. So renaming these sites to really kind of solidify and reassert that individual or that ethnic minority's place in the society that they had been rejected by, essentially. So I was then looking at, in a comparative sense, the Human Rights Chamber for Bosnia and Herzegovina, and looking at the way in which they had dealt with an instance in the Serbian part of Bosnia and Herzegovina, the Republika Srpska, in a city called Banja Luka, where 15 mosques had been destroyed as part of the cultural eradication that accompanied the Bosnian genocide. Now, this case came before the Human Rights Chamber. It's the Islamic community in Bosnia and Herzegovina against Republika Srpska case, if anyone's interested in reading it for themselves. But the court essentially ordered that the way of dealing with this was to force the government of Republika Srpska to facilitate the reconstruction of these mosques. Now, the thing that really resonated with me about this case is that it isn't a sort of a passive passing off of a sum of money. It's a process that involves mutual reconciliation and actually constructively, literally and figuratively, building a new common future and common sense of belonging in society. Now, obviously, I think asking human rights remedies to solve these issues is unreasonable. But I do think that there are elements in which, I suppose, sort of the conventionality of legal process and the kind of sources that we look at guide us away from things that are social and cultural and that maybe affect people on a more sort of nuanced semantic level. And that these kinds of remedies, so commemorative remedies, symbolic remedies, orders to rebuild sites and memorials. I haven't touched briefly on similar cases where memorials have been uprooted, and the sort of complex balancing processes that accommodate that. And I think possibly towards the end of my article, I turned to the fact that these are inherently ad hoc measures. They respond to a very particular set of circumstances in a very particular way. I think they respond to those very well, but it's difficult to translate that into a general practice. And I think seeing these as sort of suboptimal solutions to extreme situations is appropriate, but I think that there's something that should be considered more broadly when we look at human rights adjudication and reparation. So yeah, that's sort of the focus of my article. I'm looking forward to talking about it and answering any questions if you have.